Next matter to come before the court this morning is Mary Ann Rubin et al. Versus Elsie Jenkins. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we are ready to proceed with it.
Thank you. Good morning, Your Honor. Nina Nishar on behalf of the appellants. Please, the court, I'd like to reserve 5 minutes for rebuttal. You have the benefit of the briefs, and I think our position was set out pretty clearly in our principal brief and in our reply. Of course, I'd like to point out just a few things and answer any questions you might have. The issue below and the issue before the court is whether disqualification in October of 2015 was proper on the motion for sanctions. Ms. Jenkins' counsel, actually, and not Ms. Jenkins herself, alleged that because Mr. Banks prepared an amendment to her trust in 2011, and he did not prepare the trust that had been in effect since 2004, because he prepared an amendment that a conflict existed that would require disqualification. First,
he also prepared the power of attorney, did he?
Oh, yes, Your Honor. But I don't believe the power of attorney was part of the record below. It was just an allegation as to the part of it. And I may be wrong.
Okay.
But was disqualification the only thing that was sufficient to warrant sanctions? Was there also another issue?
We never heard the motion for sanctions because counsel was disqualified when we appeared for the motion. Am I answering your question?
My question was that there was also the application for the guardianship that was.
No, Your Honor. The application for guardianship had already been denied back in December, and then the motion for sanctions was filed. So at the time that the motion for disqualification was filed, the case had already been pending for 18 months.
But wasn't part of the substantial relationship argument that was being made was there was a substantial relationship because of the fact that Mr. Banks filed the guardianship, and must have been you were named in the document to administer. Right.
Yes, Your Honor.
I'm thinking that was, and correct me if I'm wrong, wasn't his argument that that was evidence of the substantial relationship, that analysis that's required when we consider the issue of disqualification?
Well, Your Honor, I believe that the analysis on substantial relationship was in error. The trial court that made the ruling on disqualification was a different judge than heard the guardianship. So if there was a substantial relationship between, the trial court assumed that there was a substantial relationship between the amendment and I assume the motion for sanctions, or implicitly the guardianship. However, there was nothing in the record to support that. The amendment was only to change, it wasn't to establish how incompetence would be established. It was only to change the name of the successor trustee and a couple minor distribution changes. But the problem is that Mrs. Jenkins was competent at the whole time, was alleged to be, or was determined to be competent. So from 2011, when Mr. Banks prepared this amendment for her, she was aware throughout the whole period of the guardianship that he had been her lawyer. And in fact, in June of 2014, when she signed an employment agreement with Mr. Hipp, and she specifically terminated Mr. Banks at that time. So both counsel and Mrs. Jenkins knew at that time that he had been prior counsel. But I don't think specifically, Your Honor, I don't think there is any substantial relationship whatsoever, because there was no issue as to the guardianship as far as the amendment. There was no issue. The issue before the court was the motion for sanctions for frivolous conduct. And if you look back to
that frivolous conduct was filing the guardianship without the expert reports?
It was filed after the guardianship was dismissed, Your Honor.
No, I understand that.
Oh, I'm sorry that I didn't understand your question.
the sanctions was for, based on the improper filing of a guardianship without adequate documentation, correct?
Basically, Your Honor, yes. But neither side appealed that, and we assumed that the case was concluded. And we could have appealed that, Your Honor, and there were good grounds to appeal, but Ms. Rubin felt that her job was concluded by bringing what she thought was the incompetence and the blindness, which is undisputed, to bringing those issues to the attention of the court. And the court determined that guardianship was not needed, and Mrs. Rubin did not ask for her to be appointed or for me to be appointed. She asked for an independent person to be appointed. So there was no benefit to her, there was no benefit to us. According to counsel for Mrs. Jenkins, there were no assets, so there was nothing to be gained except to protect Mrs. Jenkins through the guardianship. And I think that a serious issue is that even if there was a relationship, which we don't believe that there's a substantial relationship, there was absolutely no confidential information which could have been conveyed, contrary to what the trial court found, because it's undisputed that any information that Mrs. Jenkins gave to Mr. Banks, and I don't think there was any allegation she gave it to us, to me, but any information she gave to Mr. Banks came through Mary Ann Rubin. So there being a third party involved, there couldn't be any confidential information that was protected by attorney-client privilege that would preclude counsel from proceeding further.
Counsel, what about the appearance of impropriety?
Well, I believe that the cases we cited in our brief state that the appearance of impropriety cannot be used to disqualify counsel. There has to be some specific facts and evidence. And the specific dilemma in that regard is that Mrs. Jenkins never came to any hearings. Her daughter was named in the guardianship, and she never filed any objection or came to any hearings. Mrs. Jenkins was deposed, and her deposition testimony, we set forth the details in our brief, her deposition testimony contradicted the affidavit that her counsel filed. And one of the glaring contradictions was that her counsel filed saying that her assets from her inheritance were somehow absconded by Mrs. Rubin because she purchased an annuity. And Mrs. Jenkins, in her deposition, this was one of the clearest instances that she was able to articulate in her deposition, was that she purchased that annuity. She was in her 80s. She felt that she wanted yearly payments. She signed off, she had acknowledged unequivocally that she signed off to purchase that annuity, and she understood everything about it and received documents for it. And yet her counsel comes and says, well, basically, not in these words, basically Mrs. Rubin tricked her into purchasing an annuity so she could make a commission. Well, if you go through the instances in Mrs. Jenkins' deposition, she signed every document. The power of attorney was not used. The documents that was alleged about a foreclosure of her house, she signed in front of a notary who we were not involved in. Mary Ann was not there. Mary Ann Rubin was not there. And so she swore to those things. She had other documents signed before notaries. And with regard to that annuity, throughout the course, when we finally got to the hearing and the day that the disqualification arose, Mrs. Jenkins did not even know that there was a motion for sanctions pending. She was asked specifically. She said she didn't authorize anything to be filed at that time. And she said that she didn't know that her counsel had tried to get the annuity refunded. And in fact, we learned independently that he did get the annuity refunded, and he was holding Mrs. Jenkins' funds, and she didn't know anything about it, and he didn't bring it to the attention of the court that he had received the funds that he was alleging had been absconded. So I believe that this motion for disqualification coming so late into the case is being used for a strategic advantage and not for a proper purpose. In fact, part of I know this seems to be such a minuscule thing, but part of the proof of the evidence that we believe was vindictive is the filing of Mrs. Rubin's driver's license enlarged. If you see we had it sealed eventually when we learned of it, but there was her driver's license was enlarged this big and filed with the court so that it was public record. It had her social security, her no home address, her birth date, and there was no reference to it in any document that was filed, so there would have been no purpose whatsoever to file that. And I think that coupled with the fact that Mrs. Jenkins' counsel's affidavit contradicts most of her deposition testimony, I think that the combination of those things and the fact that Mrs. Jenkins, did not want anything filed must lead us to the conclusion that the motion for disqualification, coupled with the fact that she already knew, was competent and already knew that Mr. Banks had previously represented her and didn't raise any objection, I think that all requires a conclusion that the motion for disqualification was not based on fact, but was rather based on seeking strategic advantage, which is improper.
Okay, and with that, you have 4 minutes and 30 seconds.
Thank you, Your Honor.
May it please the court, I'm David Hipp. I represent Elsie Jenkins in this matter. This has a bunch of peculiar facts in it, and I think all of these cases where conflict of interest and disqualification arises because of the peculiar facts. I've cited the National City Bank versus Sarvey case as our primary authority here. It's a 9th District Court of Appeals case from, I think, 1990. That case deals very, very thoroughly with the issue of conflict of interest and disqualification of counsel. It sets out the traditional three-factor test here, whether there's an attorney-client relationship, and that's sort of admitted here. The third part of that test, and I'll address that first, is whether the client's confidences may have been, whether the attorney became aware of the confidences of the client. Now, I've heard here the suggestion that because a third party was present, there's no confidence. That's not what confidence here means. She's referring to the attorney-client privilege on testimony, not the confidences of the client. You could bring a daughter or a son-in-law or whoever in to see the attorney and talk about the confidential matters involving your Mrs. Jenkins. Those are still confidences which are to be protected. It's not the evidentiary rule.
Is there a presumption of shared confidences just by reason of the fact that there was an attorney-client relationship?
In this case, there certainly would be, because the attorney-client relationship dealt with personal matters such as the trust, what would happen to Mrs. Jenkins' property upon her death. Those are personal matters between the attorney and the client. Those are the confidences. Simply because of the relationship and dealing with those issues, I think it has to be presumed that the confidences were disclosed. There's case law I've cited on that issue, that simply because of the attorney-client relationship, it's presumed that there are confidences.
Thank you.
The second test there is whether the matters are substantially related. It's my belief here that we don't have substantially related events. We have one continuous event involving 2 different matters. The change of the trust to provide that Mrs. Rubin would be the successor trustee and Ms. Bashar Banks would be counsel for the trust. After that's established, the incompetency of Mrs. Jenkins would be the trigger for that happening. Then Marianne Rubin, through her attorney, pulls the trigger in that condition, which automatically would result in change to the successor trustee and the successor trustee's attorney. Thus the filing for competency. And the court understands that the competency, or the application for appointment of guardian, was facially invalid. Did not invoke the jurisdiction of the court because of the absence of the independent evaluation. The court was lenient, giving additional time to submit that. what they got was essentially an optometrist report that 3 years ago I saw this woman, she appears to be blind, and specifically stated no opinion about competency. I had filed a motion to dismiss. A second evaluation was produced from a doctor, apparently arranged for by either Mrs. Rubin or her attorneys, and that report made it clear that there was no basis for guardianship. As far as that doctor would go is she could probably use some help in handling the matters, for she's blind, but no issue of competency. Finally, my second motion to dismiss, the case was dismissed. No basis for guardianship at all.
What about the argument counsel makes that the request was for a neutral?
That's peculiar. If you look at it, I think the application is in the file, maybe attached to one of the briefs. The application was for a guardian, and handwritten in there, I believe, was a note that an independent guardian was asked for. Except that the application was signed by Mary Ann Rubin. She also filed an acceptance of appointment as guardian. I don't know when that handwritten note was added, but it was not part of the printed document, and it was not consistent with everything else that she had signed and filed.
Remind me what the handwritten note said.
It's a little notation after at the top. I don't have the exact language, but it said something about someone else being appointed.
Be independent.
Implying other than Mary Ann Rubin. Regardless of that fact, what happens is the trigger is still pulled. Mrs. Jenkins is found to be incompetent, and the terms of the trust would apply. There's one other thing concerning the conflict here, and that is we don't just have a situation where someone may benefit from the conflict. We have a situation where we have a fiduciary who's going to directly benefit. It's Mary Ann Rubin. She was, by her own admission, the advisor for Mrs. Jenkins, handled her matters, had a power of attorney. That sets up a worse situation than the Sarby case, because there wasn't the issue of fiduciary there. There was here. The act of filing the application for guardianship, knowing the consequences of filing the competency, certainly violates a fiduciary arrangement. I pointed out, and Judge Dunn did also, the provisions of Professional Conduct Rule 1.9. If there is a conflict, the client must be fully informed of that, must make a knowing waiver, and it must be in writing. None of those things occur here. Clearly, there's a violation.
Counsel,
Yes?
it seems to me that a significant amount of happenings occurred that perhaps could have raised as a conflict. Yet it's for the motion for attorney's fees that it was just raised.
That's right.
Whereas if I were to, in my mind, think there was a conflict, all those other things, it seems the red flag would have been raised. The motion for attorney's fees, I don't know. Why then?
It could have been, the motion to disqualify could have been filed upon filing of the application for guardianship. No question about that. It was my decision to wait and have it dismissed because the application was facially deficient. Didn't raise the jurisdiction of the court. That would have solved the issue. Get rid of the case. We wouldn't have to go through briefs, repeated motions, waiting around for doctors' opinions. All of that could have been avoided.
But you filed for the sanctions, correct?
I filed for the sanctions on behalf of Mrs. Jenkins for having to go through that long, drawn-out process when there was no grounds whatsoever for guardianship. And it wasn't even sufficient to invoke the court's jurisdiction because there was never an opinion or report filed to begin with.
Do you think a hearing, an actual hearing is required for the trial court to make the decision?
On sanctions?
No, I'm sorry, that was a really bad question, I apologize. On the conflict issue?
Yes, and I think
There
Judge...
wasn't one, was there?
Yes,
Or was there?
Judge Dunn issued his decision.
Well, there was no testimony, I guess. I think
I'm
it's where Judge
talking
Kelly has
evidentiary
one.
hearing.
Evidentiary hearing. No, I believe the judge went by the exhibits that were produced the statements of counsel, and there was the deposition of both parties, Mrs. Jenkins and Mrs. Rubin. So there was sworn testimony filed with the court. So the court had that. And it set up the outline of the case as we discussed it here. So the court was not without factual information under oath to review the situation as raised. The last thing I want to deal with is the issue of waiver. Sarby deals with the issue of waiver, and there's no specific time in which a waiver occurs on a claim of conflict of interest. I think in Sarby, it was 7 months. Sarby cites cases that go on as far as 10 years. The waiver, if it's to be considered at all, has to take into consideration the facts of each case, whether this essentially really prejudice to the other party. And also, Sarby pointed out specifically that any waiver has to take into consideration the nature of the issue, specifically referring to rules of professional practice back then. It was like 105 or something like that. That is an important thing for the court to look at. The peculiar issue here is if the court were to look at the waiver issue and find that there was a waiver, after finding that there was a conflict of interest requiring disqualification. If the waiver is granted, the court essentially is saying there's a conflict, but you can continue doing it because that's been waived. And I don't know of any court who would justify continuing violation of ethical provisions by allowing a waiver to stand here. Again, there's no prejudice to the other party here. The evidence is pretty clear, the facts are pretty clear, the documentation is there. So I don't believe that waiver is a legitimate claim here by the parties. One thing I will mention, simply because it was mentioned by the appellant here, there was no admission that Mrs. Jenkins signed the mortgage to her houses. This is another issue here. We resolved that case on Mrs. Jenkins' behalf when the bank foreclosed on that mortgage. We settled that. Our claim was she did not sign it. That issue was settled in the mortgage foreclosure case, not involving Mrs. Rubin at all. Secondly, the suggestion here is that I recovered money that was not disclosed or not turned over. I went after the insurance company who issued the annuity. The insurance company refunded after a lot of argument, and that money was used to pay the nursing home costs of Mrs. Jenkins, who had gone months and months and months without payment because Medicaid denied the application Ms. Rubin filed on behalf of Elsie Jenkins because she got rid of the money she could have used for her own care by putting it into this silly annuity, which would run 10 years for an 89-year-old woman, generating about $9,000 a year. That money was repaid to the nursing home. She is now on Medicaid because she's spent down all of her assets. That's the issue here, not that there's any money being withheld. I did what I could to put her in the best situation as possible, and that's what the money is.
Did Medicaid just assume that she was trying to hide the money?
I don't know they made the assumption. They simply made the decision that she had disposed of assets she could have used for herself, and the term of that annuity, being 10 years for an 89-year-old person, was not reasonable. And that's their decision. I don't think they suggested Mrs. Jenkins did it directly herself. She can do things for herself. Unless you have any other questions, I have nothing else for you. Thank you.
I might just briefly respond to what counsel's argument. First of all, it was never our position that Mr. Hipp took money from Mrs. Jenkins. It was our position that he filed an affidavit which contradicted his own client and also contradicted the truth. He knew he had the $9,000 and Mrs. Jenkins' possessions in his possession when he told the court that she didn't have any assets. He knew he received the $56,000 or $65,000 from this return from this annuity when he told the court Mrs. Jenkins didn't have any assets. And the point of that is, we are not contending that he used it for an improper purpose, only that the court should have had an evidentiary hearing because his own client, Mr. Hipp's own client, her sworn testimony from a competent person contradicted the information that he put in his affidavit. And it was interesting to hear counsel today indicate that he knew he could have filed a motion for disqualification when the guardianship was filed, but he decided to wait because I believe his affidavit also stated that he didn't know anything about Mr. Banks' prior representation until Ms. Jenkins' deposition in 2015, and he filed his motion 12 days after he learned it. I think the 12-day thing is in one of the affidavit that he filed. As far as the initial application that was filed for guardianship, the document that was filed at the court, it was handwritten that an independent guardianship was requested, but that's because there's no way to type in except in the spot. If you look at that application, you'll see that it's handwritten in because there's no way to type that in unless you have a typewriter, and I don't know how many people have that in this day and age. But do you have one, but it's in storage. But also in the affidavit, which was attached to the application, is Mrs. Rubin's affidavit where she requests, in the typewritten affidavit that was filed with the application, she requests an independent guardian be appointed. I'd also like, I don't know if I mentioned it before, but the trust that was originally created for Ms. Jenkins was created in 2004. There's no allegation. Mr. Banks clearly did not prepare it and was not even in the picture till 2011, so there was no dispositive issues that he was taken care of that had to do with the substantial assets of Mrs. Jenkins. The expert opinion of Dr. Lewis that the court said did not support an application for guardianship. There was no dispute that she was blind and that she needed care, daily care, every day. So whether the guardianship was granted on mental capacity or physical capacity, she needed help. And even Dr. Lewis's report said that she needed somebody trusted, but she could choose it herself.
Didn't the application say and, not or, as far as the mental and physical capacity is concerned?
I would have to look at it, Your Honor. I think it might have said and, or and/or, and/or, I'm not sure.
I want to know what
I'll take your word for it. If you say it says
I
and,
didn't see the application.
then I would agree to that.
Briefs.
But the issue at this point isn't the guardianship, it's the disqualification. And so I don't, whether it said that or not, I don't think it's relevant to the issue that's actually before the court now. And also, the power of attorney and the successor...
Isn't it relevant though? Because I don't want to skip over this. When we evaluate the shared confidences aspect of the case, that's part of the test, isn't it?
I don't think it's relevant because Mrs. Rubin was involved in the confidences. I don't think that there are any that
Well, do you agree that there's a presumption of shared confidences when there's an attorney-client relationship, which you agreed there was with Mr. Banks, correct?
well, I don't think that there is a presumption of shared confidences when there's other people involved. When other people have knowledge of something, Mary Ann Rubin could have gone out and told who knows how many people.
So you don't see a distinction between an attorney-client privilege and shared confidences as discussed in some of the case law?
I think the distinction, first of all, there has to be a benefit, and I don't think there's any benefit, but I don't think that, I think that the privilege or the requirements for disqualification requires confidentiality between the attorney and the client, not when a third party is involved. I think that that's when it loses its confidence. You're holding your button, so I'm on.
You're over my line to answer
Okay.
Josie's question, so.
All right, thank
We
you.
do think that it was too late. It was filed, so the application was filed too late, and there was no grounds. Thank you, Your Honor.
Thank you for your presentations today. The court will take the matter under advisement and issue a written decision, which will mail to both sides as well as post to our website and at the Supreme Court.
Thank you, Your Honor.